Well, that's the end of the sentencing hearing for Tamara Lynch and Chris Barber, and we're going to be coming back on September 12th to argue the seizure order, the forfeiture order for Chris Barber's famous truck, Big Red. The Crown wants to take it and destroy it. So that's only including Chris Barber. Tamara Lynch and her counsel are not involved in that. That's going to be on September 12th. Mr. Barber's son and his parents have an interest in the truck, so they might want counsel. I believe that's also going to be in front of Justice Heather Perkins McVeigh. And then on October 7th, we're going to get the forfeiture order and the sentencing decision all on that day. Today was a long day. Mr. Greenspon for Tamara Lynch began the morning, and then we had Eric Granger also for Tamara Lynch take the afternoon, and the Crown got a response. I'm going to dive into the details here as best as I can. Of course, I'm very tired and it's a lot. So if you want more of the details, you can always go on X at RightBlend and see my threads there if you want more of the back and forth. Mind the spelling errors. Let's get into this. The day started with Mr. Greenspon highlighting 5 really important differences that set this case out as unprecedented. And the first was that Miss Leach's means of what she did were always good. She didn't have outset a criminal intention in her means or her later on. There's no other case, as another point of these 5, where the accused worked so hard to mitigate the means of other people. She always advocated nonviolence, and I may forget one of them, but the 5th one was that the convoy itself had such a very positive impact on so many thousands of people, and we'll get into that. Mr. Greenspon actually choked up when he was reading some of the letters of support that were sent to Tamara to him for her, and he even said how many lives were changed by this, how many lives were saved, and you can actually go and see. He scrummed a little bit outside, and I was able to get some good questions in with him. He was methodical, as he always is, and he went through it, and he brought back some of the arguments he made throughout the trial, that this is the first protest he's seen in 45 years where they had a code of conduct that people were to follow, and that I might have to start the car at some point, by the way, if the lights go off, but we'll see. That there was a code of conduct, and the judge was like, well, we never heard from evidence about anyone who knew of it, but he pointed to the fact that Constable Sear was aware of it, but she never saw it. And that goes to introducing evidence. The defense made specific strategy choices in the long run, but there was a code of conduct, and we do know that Sear was aware of it. That's something in evidence. He said that the Miss Leach, again, always advocating nonviolence, always trying to basically speak up on behalf of people who felt like they didn't have a voice. Like he said, this had a very positive impact for very many people, and it goes on and on like that, right? And he attacked the notion that this is a case requiring the harshest sentence again, that he said that this is a case for an absolute discharge, and I agree with him for sure. When you look at the scope of cases that get harsher penalties and what is involved in that, and Mr. Granger did a very good job of going through 5 specific cases relevant to this one and 2 key principles in sentencing that affect this. But Mr. Greenspon summarized Tamara as someone who graduated high school, attended a 6-month college course for emergency communications, worked at 911 for a few years, and then 15 years in the oil patch, dispatching cement, and then eventually up to other things in the field. And she lost her job as a result of a breach that happened that was later stayed. And I believe there was comments about earlier yesterday errors in law in that breach, and that she has suffered tremendously. There's 45 days of trial, coming across the country all those times, having very liberty restrictive conditions, and spending a calculated 73 days in jail. That's with credit included. And the judge asked about are you going to talk about overbunking or that, but it sounds like he's asking 19 days regular time and then the rest at time and a half, making us 73 days, I believe. And again, the details, there's a lot. I'm tired, but bear with me here. We'll talk through some of the more important stuff. Again, those 5 points, I wish I could recall them all. I'm one slipping the mind, but that's just the way it is. But the sentiment of that argument was that her means were good, and that she made the effort to mitigate the means of other people who may have been or were, as the court found, causing harm. That was never her intent. That she's always communicating nonviolence. She's always communicating we're going to have a peaceful protest. And he brought back one of his famous arguments from the trial, that peaceful expression has no time limit. he spoke of how they're working with police to mitigate this in an unprecedented way. They're trying to work with police to do this the right way, but they have a message, a protest to be done. They're not taking upon themselves to usurp laws they don't agree with. They are trying to advocate for changing the laws and also for showing the government, the prime minister at the time, that they're not a small fringe minority. That's what he was saying, but that they were a significant number of people, and they were trying to show that through the numbers. So the judge is a very active listener and has been throughout the entire trial. Some people who are just observing for the first time, or some media as well observing, may comment that the judge interrupts a lot. But again, as Greenspon was asked about this outside, and he said this is the way she is, and it kind of tells us what she's thinking, what's important to her, and I think he finds it more helpful than not most of the time. And the judge is interjecting a lot of information and questions here. And one of the things she said was that, what specifically did she do to mitigate? And then he said, well, they worked with police, they had the good faith agreement with the city. And he's like, she's like, well, we don't really know about that because she wasn't at the meeting, but she sent a letter, we don't know her role in that, but she was there, she was trying to make that happen. And then we know Chris Barber's good efforts with the good faith agreement, and he brought the testimony of Kim Ayotte, the former manager for the city of Ottawa of emergency services and preparedness, protective services and emergency preparedness, which includes ambulance, fire, bylaw, protective, corporate security, and his testimony that yes, Barber fulfilled his end of the deal. They moved 102 vehicles, 40 trucks, and it was indeed the police who stopped them. And this has been a mainstay theme of Mr. Greenspon's arguments in court, and Granger and all the defense's team is, hey, they had this good faith agreement, they tried to mitigate. And then the judge kind of clapped back with, well, they were told at different times, suggested by police, okay, leave, and then maybe come in and do circuits. And he said, well, they weren't advocating, Tamara wasn't advocating to break the law. She didn't have a truck, she wasn't honking, she wasn't emitting fumes of diesel fumes, she wasn't emitting noise. She was, 5 videos was the basis, I believe he said, of the judge finding her guilty of the mischief as a principal party aider and abetter, which is the whole lot. And that's it. So he was very good at it, and there was a lot to it, but that's the gist of it. Her means were good. She set out that way. She didn't set out with an unlawful intention, as is the case in all these other, or the vast majority of these other protest cases, where protesters set out from the very beginning, we are going to do what we want, we are going to break the law because we are morally justified. And as has been referenced in this, the case law, the Supreme, or wherever the jurisprudence is from, has said that in such circumstances where someone is taking their own moral values to usurp the law, to say we're going to do what we want because it's morally right, those people have a very high moral blameworthiness, which is a very important key word for sentencing, and need to be punished accordingly. And he said, well, that's not what we had here. You have found, Your Honor, and even the Crown has agreed that this is a case where we have people who, even the Crown said, had noble intentions, but at some point crossed the line into criminality, as you found, through their unjustified risk of their words to the ongoing mischief. That's the gist of it. The Crown had a reply later where they kind of dove into that a little more, and I wish I could recall a bit more of Greenspon's stuff, but that's the gist. And he does this, and then Granger comes in for the 1-2 punch. And Granger made some great points. His main arguments were that there are 5 cases which really show the stark uniqueness of this case, and 2 sentencing first principles that are critical to this case. And of course, Greenspon, going back to Greenspon briefly, where he described Tamara and her background. She has almost 4 grandchildren, waiting on a 5th. She's been unemployed. She suffered. She had the restrictive liberty conditions, in asking Her Honor to grant her, Tamara, an absolute discharge, which would be an appropriate sentence, I think. She suffered a lot. And again, Magus asked the same thing for Barber yesterday, and said that, $100,000 bond. And I'm bringing this back up because the Crown was responding to both Diane Magus and to Tamara's counsel today. So we're going to talk a bit about what the Crown had to say in response to that. So maybe I'll get back to that when it's appropriate. Granger, we'll jump it back ahead if I recall, I'll go back. But Granger said that, again, the 2 principles that the judge must apply in this case are, first of all, the judge is directed in sentencing principle that for a first-time offender, the least restrictive sanction appropriate for the circumstances of the case must be what is imposed. So that's the first key principle to apply for the sentencing decision that the judge has to make. The second that he brought up was the impact statements made by the Crown cannot be used to lay blame at the feet of somebody who was convicted for something that somebody else did. And certainly that is the suggestion of some of these impact statements. Yes, let's dive back into that, because that's a big part of what Greenspon was talking about after that. He was talking about those impact statements, and he said there are 12 impact statements that the Crown has submitted as victim impact. Only 3 of them have the name of Chris Barber and Tamara Lynch on them. And of those, it's very clear to the defense, and the judge later admitted that's clear to her as well, that these were prepared for the civil suit. And Mr. Greenspon argued that it's not appropriate, in so many words, to have a victim impact statement from a civil suit that clearly the person giving that statement has another very significant vested interest, in this case, in the class action, which is, in my own words, a very severe conflict of interest. And besides the conflict of interest in that, there is claims, again, from some businesses. I think we talked about that. They're also class members of this suit. So same thing, same conflict of interest. And then there are, I believe, 2 institutional reports included in this victim impact statement that were presented as POAC. And Mr. Greenspon said this court has not heard that evidence. In one of the institutional reports, it says by law issued 3,000 tickets. We did not, or thousands of tickets. We did not hear that in the evidence of this case. The judge agreed. We didn't hear that. We have the evidence that we have. Can't introduce that after the fact, right? And then the second institutional report said that it was a daily count of how many people were arrested at the protest. And again, no evidence of that. And the judge also agreed. So those were key points by Mr. Greenspon. And another thing that he did, besides disputing the Crown's, let's be honest, hobbled together victim impact statements, and again with King, there was one that was made for Pat King's case. So like, why, if there was so much harm done, is the Crown copy and pasting victim impact statements, these are my words, from the class action suit in 2022 that's still ongoing, and then these institutional reports of evidence not presented, and then of a victim impact case for the case of Pat King. So I mean, you would think that if there's so much of this, they would actually be able to have specific victim impact statements naming Chris and Tamara that they could present that weren't used for some other case that they just happened to recycle, right? Or repurpose. And I think that's noteworthy. I think that's really noteworthy. And the judge seemed to kind of agree. The Crown had some snapbacks on that. We'll get to that at the end for their reply. But they basically got into, oh, well, you got to use it anyways. And the Crown's position seems to have been with us. It's not exactly specifically for what it is, but just a general overview of the scenario. And the defense is just making it clear to the judge that, hey, first of all, these people have another vested interest, and yeah, and we don't have evidence of this, that, or the other thing. Then great. And then he brought forward the letters in support of Tamara Greenspon before Granger jumped in. And Greenspon said that these letters were from people who worked at United Way as an officer for a career, so working with the most vulnerable people in society, saying that they saw the homeless being fed at the convoy. They were there. It was a diverse cross-section of the Canadian people. It was great. And then another person, a civil servant who lives in downtown Ottawa, saying they felt safe. They saw people taking care of each other. Another person who said that they had lost hope up until the convoy, and the convoy gave them back hope, and that they were in a very bad place, and more of that. And just over and over again. And Greenspon, again, was choking up reading this in court. At first, I was sitting with a very lovely woman by the name of Brenda Mason, who did many years of real journalism with the old school journalists in Ottawa back in the day before it all went upside down. And I like sometimes when I hear something, I wanna get a second opinion on it. I'm like, is he choking up? And we kind of came to the possibility that maybe he had something stuck in his throat, but he literally said it in the scrim outside. You guys want to see me break down again? He was feeling it, man, when he was talking about those victim impacts and at this convoy. He's like, as a criminal defense attorney, Mr. Greenspon is one of the most storied criminal defense lawyers in Canada. And he said, in all my very long years of doing this, we never get to talk about the positive impacts of a crime that someone we're representing has done. And in this case, there are clearly thousands, tens of thousands, he said, maybe, who were positively impacted by the convoy. But as an aside and an additional piece of information, there are approximately 10 million people in Canada who are not vaccinated. That would be millions of people who are under the worst thumb of these mandates, who no doubt would have thought felt some level of thankfulness for this protest changing the course of where things were. And to those who say, well, everything was finishing up anyways, no, it wasn't, because Ontario was playing their yo-yo game. Oh, if we get to this many, we'll go to yellow, and then we get there, and they say, it actually needs to be a bit higher, and we would just keep doing that, or we go to yellow orange, and then nope, sorry, we're back to yellow, and this would go on for, this was years in the making before people came to Ottawa. And again, the intention as expressed by the mischief makers was to come to Ottawa, peaceful, safe, lawful, and express a message and stay for the duration of expressing the message, and that there's no time limit, as Mr. Greenspon had said, to the duration of legal of expression. And Mr. Greenspon also said, besides no limit to expression, oh man, it was on the tip of my tongue and I kind of forgot it. Sorry, I'm very tired, a lot of information, and sometimes it just pops out there. But there was something that he followed up with, which was really good. Not only a limit of freedom of expression, freedom of expression has no time limit. Oh yes, the city in the test, as he brought back to in the testimony of Kim Ayotte and all that, they were very aware that the protesters intended to stay for an extended duration of time. Yet they were guided in, as we've heard, even testimony by Chris Barber in his stay of proceedings application, which was denied, that in that he said, yeah, we were guided in. And the argument was from the defense, hey, the city was aware that this was going to be a major... All right, my heart just dropped there for a minute, because I thought, because I saw that the light's not on this little mic, that all the audio I just recorded for the last so many minutes was not there, but it was. And a couple times today I was writing a tweet and it got lost because my Chromebook refreshed or something, so I lose paragraphs of transcription, which is frustrating. Then I have to jump back into the live conversation, summarize what I missed, if I even... Sometimes I don't do that, and I'll put an ellipsis or something to indicate there's some skippage. Sometimes I won't do that, so remember, it's not verbatim, I just do my very best, but thankfully it's all there. So Greenspon was representing that, and it was good. It was good. He did a great job. And then Granger, again, with the two principles. A first-time offender, the judge is obligated to impose the least restrictive sentence appropriate for the circumstances, and secondly, that the victim impact statements cannot be used to introduce evidence or to say that the person did something that someone else did, right? And then the 5 cases he referenced is very distinctive in setting about just how unique this is, and in sentencing usefulness to her honor, is first the von Hugenboss decision. Second was, I believe, a case called Serranos. The third, I believe, was the King decision. Then another called Devey. I think it's a purely French case, and Miss Magus rose later to add some details for that. And the judge is going to get a transcription of that, a translation of that case at some point. It was mentioned in one of Tamara's bail hearings, so that's why it's particularly important. But this is a case these are cases the Crown has provided as evidence of mischief sentences. And then the fifth was the Norman Blanchfield case. So in the first case, Mr. Granger said that the judge over in the Coots case in Alberta found that the moral blameworthiness of someone as a aider and abetter is less than the principal. And then he talked about how there, in that case, there wasn't the level of mitigating others means that there was in Ottawa. There was no good faith agreement with the city. There was no mass movement of trucks. There was maybe a moving here or there, some good, some common communication between PLT and protesters, but not to the level seen in Ottawa. Totally unprecedented. And again, that very clear, peaceful, safe, lawful, always telling people to treat people with respect. Even the judge noted that Tamara made a video at some point during Convoy, quite later on, saying, listen, the Prime Minister is a person, he has kids, he doesn't deserve some of the behavior that's being shown towards him, and also respect the police. So the judge was noteworthy of that, and I think she appreciated that. I think that's... And then there was a reference, right? Like, these are considerations to be made down the line. At some point in her decision, she said, and Mr. Greenspon pointed out, this is now down the line. This is where we're at now. Secondly, the second case was the Serranos, and this is a case where the people set out to break in, I guess, animal rights group, where they said, okay, their moral values are more important than the law. They're going to break into this place and they're going to do these things totally unlawful from the get-go. And Mr. Granger rightfully pointed out that this is not analogous at all to the case that we have now, because that's an unlawful design, right? And in I don't know if it was Granger or Greenspon, but there was a callback to Her Honor's dismissal of the Carter application. Remember Carter, how much we used to talk about that? The Carter basically being which applies to one applies to the other, and it's based on that there was a common unlawful design that the parties entered into, and Her Honor found that that was not the case. There was no common unlawful design that Chris and Tamara entered into, because again, even the Crown admitted their initial intentions were good. And in the case of the Serranos, for example, they were set from the beginning. We're going to break into this place. We're going to break the law because our moral values are more important than the law. And of course, we know in the case law mentioned, in the guiding principles mentioned, that in such a case, the blameworthiness is very high. But that's not what happened for Chris and Tamara. It's the exact opposite of that. They had a good intention. In the third case, it was the Pat King case, which they said is the most important, most similar in circumstances, in that it was an Ottawa protest, but very different in the way that King and then Chris and Tamara conducted themselves. But he saved that for last. He moved forth to Dervey, which is probably one of the most significant convictions mentioned. I don't know if it's a mischief conviction. I'm assuming it is. 7 years. But as we learned from all the details mentioned from Magus and from Mr. Granger himself, this was a case of a guy who cut power during the middle of winter to 180,000 people in Quebec with the intention of shutting down the entire Quebec grid. And so 180,000 people, millions, I believe, in damages or losses in the middle of winter, an essential service cut down by this guy. So very clear from the get-go, he was intentional on doing this because he had a grievance with Hydro-Quebec where he set off and he damaged hydro lines. This is, to me, sounds something more like, I don't know, terrorism than a mischief, right? And intended to shut down the entire grid of Quebec. This is not at all comparable to Freedom Convoy, and obviously his moral blameworthiness and his means are initially bad on their surface bad, whereas in this case, the actions of Chris and Tamara were not found to be illegal on their surface, but in the unjustified risk of what they were doing, facilitating the means of others who were breaking the law. Very different. Very different. Right? We're talking about a guy who cut hydro lines getting 7 years versus people who said, hold the line and have love in your heart and stand up for what you believe in and be peaceful, lawful, safe. Then the last case was the Blanchfield case, which, as Mr. Granger says, cuts both ways because this was a copy. The judge in that case described it as a copycat case, but Mr. Granger pointed out, because it happened, I believe, at the Rolling Thunder months later, and Mr. Granger pointed out, well, first of all, this is a guy who came with a truck, he had a megaphone, and he was, I believe, sentenced to conditional sentence, maybe house arrest, I don't recall, but it was nonetheless not a discharge, right? So in that case, Granger points out that this is at a time where there's been months to reflect on the impact to Ottawa. They came anyways and did it anyways, so very different than the circumstances that Tamara and Chris found out themselves in throughout. And then the last case, King case, it's very clear. Granger says that Chris and Tamara had very different actions from King. King came at the beginning and said, oh, we're going to jam up the place. He took delight in jamming up King Street, according to the arguments made in court. And that he took, he's encouraging people even on the last day, as late, I believe, as February 18th, go jackknife your truck and block the cops and don't move out of residential areas and all of these things, which were in contrary to the things that Chris and Tamara were trying to do. And in that case, again, additional convictions, and his sentence was 1 year. Now, this is not my personal beliefs on Mr. King or what happened, but the evidence shows that Chris and Tamara did not advocate for anything of that nature, that they did distinguish themselves from King's actions, and in that case, again, King, periphery of leadership, but getting sentenced to a combined 1 year, 9 months time served credit, and then 3 months house arrest. And so he's saying, well, look at where we are here with the means that the noble intention Tamara never and Chris never intended to say and come. But there was one text message Granger mentioned, I believe, and the judge said this is the most problematic one. I believe it was from late January where Chris mentioned, well, we're going to jam it the F up and, F and mess it up and all that. But other than that, we can see in his actions and his good faith agreement with the city and moving the 40 rigs and the police stopping that there was good means and certainly good intention. Now, the Crown replied. Crown says, it's not, mischief is a general intent offense. The Crown does not have to prove the intent, and it's therefore shouldn't be, I guess, a consideration in the sentencing. And they said, well, in King and in all these other cases, they're comparable. They should be applied. And specifically spent some more time talking about the impact statements. They said the law says that in I believe section 21 of something says that if a letter of support is positive to a convicted offender and does not mention the crime, it should have less weight. So basically saying, and then the Crown says, it goes further than that. They don't only not condemn it, they actually talk about praising it, right? Praising which your honor has found to be a mass mischief. So the argument by the Crown in that is, okay, these positive letters for Tamara should have less weight. And then they said, concerning their victim impact statements, the victim bill of rights, I believe is the wording that was used, specifies that an impact is an impact and it has the weight that it has and it should be allowed to be used, right? So yeah, ours are good, yours are bad, right? This is always both sides play this game, but I certainly found the Greenspon and Granger's arguments more legally convincing, and the judge, again, doing her active listening, engaging with the Crown, and disagreeing on some of the things, right, on the scope of this. The Crown says we're asking for a sentence that is within the parameters set by Parliament, but at the same time, the circumstances, I think, a reasonable person, and that's another thing Greenspon said during his thing. The average person is not aware of the very mitigating factors that they did, like the good faith agreement, and that the sentencing decision must be made from the perspective of a totally informed, reasonable person. So somebody who knows about the moving of the trucks and all of these things, right? And this is something that I actually got into again with Granger and the Scrum. You can go see all those videos on my profile. I'm getting really tired, so I'm going to have to finish this up. But yeah, the Crown's basically, and then for Miss Magus saying that and also going back to the Van Hugenbos and all that, saying that no, the Chris and Tamara were not just found guilty as aiders and abettors, but as party in principle. So they got the higher moral blameworthiness there, and that Chris Barber didn't have clean hands coming into this, like Magus was suggesting yesterday, or in so many ways, obviously, because of his comments with that text message and so forward. And even though that Tamara didn't have the truck, her words was an unjustified risk to the ongoing mischief which your honor had found, right? And so sentence accordingly, I guess. That's where we're at. It's next again, there's going to be an argument on September 12th about the forfeiture order for taking that beloved, beautiful, big red truck and destroying it, because we haven't been vindictive enough in this. Oh, and the Crown was also disputing the conditions that they had experienced. They're saying, well, Mr. Barber had a $100,000 bond, but it wasn't a cash deposit. It was a promise to pay, so it's not the same. And concerning immigration issues, and the judge was very sharp. He was employment issues. The U.S. doesn't automatically prevent anyone from coming who has a criminal conviction, because these aren't crimes of moral turpitude, I believe is the language they used. And so they're just basically like, yeah, you can convict them. It doesn't bring into the special considerations of collateral punishment, I believe is the legal word used for when something's going to be unduly harmful, I believe. But nonetheless, yeah, I can't help but feeling it's punitive. What do you think? I think it is. I think it's very political, and this is my best attempt at summarizing. And let me just say again, thank you guys for following me throughout the years on this matter, and for being so supportive and enabling me to do this work and to be your eyes and ears in that courtroom. And many of the days, let's say day 2 to 44, which is me, Tamara, Chris, Barber, their families, and a couple supporters, the court officials, the judge, the police, the homicide detective, who is the lead investigator in this case, is a homicide detective. So you can imagine all the precious time on that end wasted. And 2 other people from the media most of the time, someone from CBC, someone from Canadian Press, but I was in there. I was trying to be wholesome in my reporting. I'm clear on my perspective. I'm the right blend, the right perspective for sure. And I appreciate all of you. Thank you. And if you want to support my work that I've done, you can send it to e-transfer to realrightblend@gmail.com. Thank you again. And the next time, again, we're going to come back is the forfeiture order on September 12th. I'd like to attend that. And then the sentencing on October 7th. The only issue is that, as you may or may not know, I have some health concerns. I may be requiring a heart surgery, so it may be that I am not able to attend those, which would be very upsetting because I've spent so much time on this. But it is what it is. We get the hands that we're dealt, and thank you for giving me this opportunity, and I look forward to continuing reporting the truth and getting to the bottom of stories that matter. Like, subscribe, and comment, and share it with your friends. Let me know what you think. Long-lasting protest. Is this thing still on? I don't even think this is on.